Thank you all for having me here. Thank you, of course, first to the Australian Research Council Centre of Excellence for the Elimination of Violence Against Women and the Australian Institute for International Affairs here in Victoria. Thank you, Your Excellencies, representing not only Australia, but Canada, Colombia, Japan, Kosovo, Nigeria, and your for us is, of course, critical. And is this working? I should check. Okay, before I go too far. And I'm grateful to Professor Jackie True and Professor Sarah Davies for your invitation and your work for so long, and it's informed my own understanding of what we care about together. It's good to be back in the Asia-Pacific. Most of you associate me with being in The Hague or work in East and West Africa, but I assure you, I have old ties to this region. My mom was, of course, Vietnamese, but I was in Australia as a child. I went to primary school outside of Sydney at Corpus Christi Elementary, and after we lived in Australia, my family moved to Indonesia for several years. In college, I spent time in Japan. I lived in Japan, in rural Japan, actually, before law school. And then my second summer of law school, I worked for the International Labor Organization in Hanoi, studying the trafficking of women and children in that region. And then I think right after, I think in 2005, I worked in Yunnan province in China, studying the conditions for persons living with HIV. And this was so many years ago. It really was, all of this was 20, 30, 40 years ago. And so the invitation to join you here has made me think a lot about the past decades and how time passes. We have, as a species, conceived of time in many different ways, both in nature and the passage of it. From the dream time I recall from your Aboriginal communities here, to the tool, perhaps, of ancient Mongolia, which refers to the migratory and nomadic cycles of herding life, for example. But I have been thinking recently, before coming here this week, about the ancient Greek concepts of chronos and kairos. The former, chronos, refers to linear time that passes in measurable units like seconds and hours, days, months, years. And the latter, kairos, refers to a more qualitative aspect of time. It's the rightness of a moment, the perfect alignment of conditions that sparks an opportunity to do something, right? It is the perfect alignment of conditions. It's the quality of a point in time rather than its duration or its place in a sequence. So as we prepare and think about this 25th anniversary of the Women, Peace and Security Agenda, it is of course appropriate, as the Baroness has said, and as Professor True led us to think about in the beginning, to cast our gaze back through time and to have a clear-eyed look at what we've set out to achieve a quarter century ago and see how close we have actually come. I assume we'll do that together these next few days, but perhaps you'll allow me to just start us off by unpacking one aspect of this conference theme of justice denied, and that is a question from the corner in which I sit. They say that justice delayed is justice denied. And so I wanted to interrogate these delays in justice together. And if we hope to see the promise of the WPS agenda in this next quarter century, what can we do to hasten justice for conflict-related sexual violence? So I think it's better if I put my reading glasses on. I'm now a full 50 years old, speaking about the passage of time. And so maybe we start. The Baroness gave us already a very nice overview of the WPS agenda and its specific goals for justice and accountability. So maybe we can just recap some of that. We know, of course, that Security Council resolutions 1820 and 1888 emphasize the need to enhance efforts for national and international prosecution of conflict-related sexual violence, and it called on member states to strengthen their own judicial capacities and implement legal reforms to prosecute perpetrators effectively. The agenda also references, of course, the use of other international mechanisms, international tribunals, of course, but also utilization of measures like sanctions against people believed to be responsible for these crimes. And then the resolutions as a cluster refer repeatedly to the need to document as we go, whether or not a tribunal exists to prosecute at the time. The active documentation helps us build a baseline of information and that can be used in later prosecution and accountability processes. And then also taken as a whole, the agenda repeatedly through different resolutions emphasizes the need to attend to survivors and take them into the process, make sure that they have a role and a voice and can guide every peace negotiation, even the justice processes that they're brought into. Resolutions including 1889 stress the importance of ensuring that survivors receive essential medical, psychosocial, legal, and financial services, that they can access trauma-informed care, reproductive health services, and support for societal reintegration. Other resolutions, like 2467, emphasize the protection of survivors and safeguarding them from retribution and other forms of harm. The agenda at its core insists in not only involving survivors in peace negotiations, but in justice processes. And this is really where I wanted to situate my reflections. But first, what progress have we made in fighting conflict-related sexual violence this last 25 years? To be honest, and I maybe echo some of the Baroness's comments here, it's hard to say if we've actually put a dent in it. We read with daily horror in the news about ongoing violence in Darfur, Eastern Democratic Republic of Congo, Myanmar, Afghanistan, Palestine, and Ukraine, crises in which gender-based violence in some form or another runs rampant still. Quantifying either overall incidence or prevalence of this form of violence is complicated, primarily because of the constant challenge and understandable challenge of underreporting, but also because assessing any increase or decrease requires first that we have a baseline measurement, and we just don't have a good one, to be honest. And not everyone is measuring the same thing. So it can be difficult to aggregate quantitative claims about conflict-related sexual violence at a global level. And yet, we have made progress, and we can see that in some local contexts. We can also see some observations from the corner in which I work. So in the legal sector, first of all, our jurisprudence and charging has progressed in the last 2 decades and a half. In addition to rape, of course, which has traditionally been the primary form of conflict-related sexual violence presented to and acknowledged by courts, we have now also seen acknowledgement of a range of war crimes and crimes against humanity in particular, including conduct such as sexualized torture, forced pregnancy, slavery, including sexual slavery, forced marriage, as we've heard, forms of reproductive violence that may or may not be sexual, actually, and forms of gender persecution, which again, may or may not be sexual. And it's important to keep all of this, to widen the aperture, so we're not just fixated on what may or may not be sexual in a specific context, right? At times, it feels like 2 steps forward and 1 step back in the courts, but the base jurisprudence regarding sexual violence is indeed growing slowly. Second, we've seen an expansion, and it's okay. We've seen an expansion of the understanding of who might be victims or survivors of conflict-related sexual violence. We all know by now that, for example, the International Tribunal for the former Yugoslavia dealt quite often with men and boys who had suffered different forms of sexual violence in the conflict there. More recently, at the International Criminal Court, in the case of Dominic Ongwen a few years ago, ICC judges recognized that children born of wartime rape are themselves direct victims alongside their mothers. They're not derivative. They are not some incidental beneficiary. They are victims because their existence poses lifelong challenges for them. The ICC judges also recognize that intra-rank sexual violence can be prosecuted as a war crime. We won't go into the technical debate about this in international humanitarian law, but this was not a given, actually. This came in the case of Ntaganda, and it is actually an issue before the amazing Transitional Justice Court in Colombia in their macro case number 7 right now. Third, as a sign of progress, the ecosystem for accountability for conflict-related sexual violence has expanded dramatically in the past 2 decades. We have, of course, around the same time as the WPS agenda was born, the International Criminal Court was stood up in The Hague. But really, there are exciting developments at the national level, including the establishment of special prosecution orders and in the domestic judiciaries, some for gender international crimes, as we see in the case of Ukraine. For Syria, Myanmar, and Daesh crimes, of course, we need UN international accountability mechanisms gathering and collating evidence for in other tribunals. And of course, the WPS agenda gave us the UN Office for the Special Representative of Sexual Violence in Conflict, currently held by Pramila Patten, and the team of experts. And this group keeps conflict-related sexual violence front and center in front of the Security Council, but also supports national systems in their prosecution of these crimes. And then finally, a fourth development to note. In recent years, we've seen widespread acknowledgement of the need for survivor-centered and trauma-informed approaches to this work. This was not a mainstream conversation 25 years ago. I will raise this more later, and this progress is thanks to many of you in the room, and I hope that we'll hear more about it from you in your presentations today and tomorrow. So despite this progress, we still, of course, have many, many challenges, including that of delay and the failure to deliver swift justice for conflict-related sexual violence. Why is it urgent to understand and address delay specifically in the justice sector? Well, obviously, it compromises access to justice for survivors. It then compromises and delays their access to reparation. And it frustrates any hope of prevention, right? Deterrence theory holds that prosecution, for it to have preventive effect, the commission of new crimes, there must be three things: certainty, or the likelihood that one will be caught and punished for a crime. There must be severity, or the appropriate harshness of that penalty for the crime. And third, it requires celerity, which is a fancy word for the speed at which punishment is meted out and administered after a crime. And so time is important if we want to believe that prosecution has any deterrent value at all. But let's start with the first concept I mentioned, chronos, right? What are the actual measurable delays when it comes to the prosecution of conflict-related sexual violence? When we look at the time lapse between conflict and the alleged commission of crimes and investigation and final judgment, we're maybe talking about three general categories of delay. First, we have contemporaneous or near contemporaneous trials, maybe between 0 to 5 years of the commission of crimes. Now, if we think back to Nuremberg and the Tokyo tribunals, even the UN War Crimes Commission that guided domestic prosecutions after World War II, these decisions came out quite quickly. They were all rendered by 1948, 1949, actually, right? They're rough justice. These were not cases prosecuted to the same level that we have now with the development of international criminal law. And they're not full justice. There are many things that were not brought to the table. But it was swift. So presumably, one might say that counts for something. And in the cases between Nuremberg and some of the UNWCC domestic trials, crimes of sexual violence were actually addressed. Sometimes we think that it was not addressed at all, but actually there was evidence of rape and forced prostitution considered by the judges in many of those cases. Another example, more current, in Ukraine, ongoing conflict, and I have before, during, and hopefully after my time at the ICC engaged with Ukrainian prosecutors and investigators. They have now hundreds of active cases and investigations of conflict-related sexual violence coursing through their system right now. And we're waiting to see the outcome, but it is exciting and quite inspiring, actually, that those cases are being brought while conflict is ongoing. We see similar progress in Central African Republic amid ongoing conflict. The Special Criminal Court in Bangui has rendered multiple judgments, including for conflict-related sexual violence, amid ongoing insecurity there. And then we see through universal jurisdiction, courts in Germany taking up cases, for example, about sexual violence happening recently in Syria. The next basket, I think, of cases we see in delay, which would be medium delay, maybe, between the 5 and 10-year range between commission and trial. And here we're looking at, if we cast our memory back to the international tribunals for the former Yugoslavia and Rwanda, the time frame between the alleged the acts, the conflicts in question there, the genocide in Rwanda, and when judgments issued from those two tribunals was within a decade, actually. This is not fast. It's not also slow compared to other cases. Similar speed was seen at the Special Court for Sierra Leone, where Justice Taylor had worked. And this was also quite a model in terms of the gender-based crimes brought through the cases and also the amount of time in which it took to resolve some major, major jurisprudence. These were cases involving rape, sexual slavery, forced marriage, and the use of child soldiers. And finally, our third category, which perhaps disturbs us quite a bit, these are the categories of cases where it's long delay, decades and decades of delay. It took 40 years for the extraordinary chambers in the courts of Cambodia to be created and adjudicate case 002, for example, addressing forced marriage in the Khmer Rouge that had been committed in the mid-1970s. In Guatemala, we see a similar story. It took over 30 years to bring the Sepuzarco case and render judgment for the rape and sexual servitude and domestic service forced onto indigenous women during the country's 36-year civil conflict. Or there's a case that I worked on, the former president of Chad, Hissène Habré. The crimes committed under his rule between 1982 and 1990 did not make it to court until 2015 across the continent of Africa in the courts of Senegal. It's a very long story. I won't tire you with it just now, but essentially, it took a group of dedicated victims. It took their surprise discovery of a treasure trove of documents by Habré's security forces. It took the election unexpectedly of Macky Sall, who replaced the former president of Senegal, who was allowing Habré to have asylum in his country and remain uninvestigated, unprosecuted. And then it took the last-minute disclosure of rape and sexual slavery and forced contraception by Chadian women who only came forward once they saw and were sure that their former president would be sitting in the dock. And that's when they told their lawyer, they pulled her aside. One woman first said, this is on the eve, this is almost before investigation phase was over. She said, I haven't told you this before, but you know I was detained, and you know what happens to women when they're detained by men. And that she opened the door there when she knew that this trial was going to proceed. And when she stepped through that door, dozens of other women also followed her. And that's how these charges became added to that case and became part of the conviction. I was there in the courtroom for the verdict, by the way, and these women came back from Chad, and I sat in the row behind them, and they were old now. This is 30 years after the violence committed against them. And when Judge Kam read the verdict out loud, the women, there were about 12 of them, they stood up in the row and they just started singing. And it was incredibly moving to see them in their old age just release this song together after having waited, I think, for literally decades. So short, medium, or long delay, how do these cases come about then, if at all? If we think about Kairos, why can it be so difficult for the moment to become right, or at least right enough to try? There are many reasons justice can be delayed. One could borrow from the public health model for a minute and think about it, break it up into a rough ecological model. This is not something the lawyers in the room are familiar with, but the public health people know what I'm talking about, right? So if we look at one level, the political and the legal level, here we're talking about state, community, stability, and security. We're talking about access to appropriate legal frameworks that allow you to even bring these cases under domestic and international law. We're talking about the political will to effectuate an arrest of an accused person and take them to trial, either in your own court, so universal jurisdiction perhaps, or to effectuate arrest when that person visits you and extradite them somewhere that will actually prosecute. Second level, maybe a different level, we're talking about challenges at the technical level, investigation, procedural issues. This refers to whether we have investigative capacity, whether that is gender competent investigative capacity. Do we have resources? Do we have realistic deadlines to actually get meaningful work done? Do we have access to territory? We don't always, and that complicates things quite a bit. And for international criminal law cases, and this is where it differs quite a bit from domestic cases, one must establish not only the crime base, right? What happened to whom, when, and where, but linkage to specific persons, plus fulfillment of contextual elements that would make that act also a war crime or a crime against humanity, or potentially an act of genocide. And then we look at the level of challenges at the individual survivor level. If we take a page out of behavioral science, we might say that a person's decision to do something, to do anything, is influenced by whether they have the capacity, the opportunity, or the motivation to do that thing. And so when we look at disclosing your experience of conflict-related sexual violence, do survivors have readiness and capacity, despite impacts of trauma, their competing priorities, or their sense of safety? Do they have opportunity? Is there a legal avenue in place, and can they access it? Do they have motivation? Do they ultimately believe disclosure will be worth it? All of these stars eventually aligned in the cases I mentioned earlier, obviously, but there's of course active pushing over the years to draw those stars closer together. In the case of Hissène Habré, none of this would have happened without the tireless work of victims' associations and their fortuitous partnership with Human Rights Watch, or the commitment of the African Union, Chad, European states, and even the United States, believe it or not, to fund a special judicial chamber in the courts of Senegal. And also, of course, the slow trust that grew between survivors and their counsel and the system itself. We are still waiting for the alignment of stars in many places, including in this region. We have movement with respect to Myanmar, with cases both at the ICJ, the National Court of Justice, and the National Criminal Court, and an independent UN mechanism gathering and analyzing evidence for use in multiple jurisdictions. But the challenge, as always, will be to secure the arrest of persons accused of these crimes. The International Criminal Court also has, as you know, an investigation into Afghanistan focused on the crime of gender persecution as a crime against humanity. And again, the likelihood of arrest is slim for now. It will require both opportunity and will. And we really wanted to thank all of you in the room who contributed to the efforts there. And what about East Timor? Transitional justice measures have not led to meaningful prosecution or reparation for conflict-related sexual violence committed from 1975 to 1999, which reportedly included rape, sexual slavery, sexual torture, and the often gendered or sexualized abuse of stolen children taken from their communities. And Sri Lanka, Papua New Guinea, how long will it take for the stars to align there? What can each of us do to pull them a bit? So, justice delayed? Is it justice denied? It is. It is in many ways. And even for those conflict-related sexual violence survivors who do eventually engage in formal justice processes, once they've shared their accounts at an investigation stage, they may wait years before that evidence, their personal life experience, is shared in a courtroom. And that wait can be agonizing. Many of the witnesses also have specific challenges, exposing themselves to great insecurity and stigmatization because of the specific harms they have shared, should it become known to their communities before trial. And it often does, huh? But the majority of survivors never touch a justice process, never make it to court. They may wait decades for acknowledgement, for reparation. They keep secrets from their loved ones. They pass their perpetrators in the street. They raise children they never planned to bear. So, in a way, there is a paradox here too. What I'm asking us to consider is that we shouldn't delay, but also we shouldn't rush. Before we assume that all delay is a bad thing, we should also remember that a survivor-centered approach to justice takes additional time. It presents complicating truths. It almost never moves you along faster, and if anything, it actually requires much more time and planning and care. But it's important, it's the right. Let me share 4 observations here. First, thorough investigation for international crimes in particular takes time, and we owe it to survivors of conflict-related sexual violence and all witnesses to bring the strongest case possible. This might be obvious, and I alluded to some of this earlier, but it bears reminding. Unlike with the general documentation of human rights abuses, investigation of international crimes takes a particular degree of time and certainty. One must establish not only the crime base, but, and this is where it gets complicated, how the conduct on the ground can be attributed to a specific accused person. At international tribunals, it's almost always a high level or a medium high level commander who is not physically present at the scene of the alleged conduct. How does one prove this connection, the personal culpability beyond a reasonable doubt? It takes time to cross your T's and dot your I's in this, even before you apply for the arrest warrant. Prosecutors have to show they have a strong case in order to get an arrest warrant or charges confirmed in the first place, right? The stakes are high. They're proposing to put someone behind bars for decades. And they must be confident they have strong prospects of conviction before even bringing the charges forward, or every witness they engage and whose evidence they're using risks being exposed to the defense for nothing. Second, conflict-related sexual violence do not always see themselves or their experiences in the same way. I know you know this. Those of you who also work with survivors know this very well, and forgive me for stating what might be quite obvious. But experiences related to armed conflict are diverse, and they're not all survivors who have the same violations see themselves as even survivors of conflict-related sexual violence specifically, especially when they've experienced a continuum of gender-based violence throughout their lives, or potentially a multitude of different harms in the context of the same armed conflict. In fact, in my experience, both representing survivors and studying their experiences and needs, it seems clear that conflict-related sexual violence is often just one of the horrors most people have lived through. I've worked with women who saw their husbands executed, their children taken away, their homes burned, their livestock slaughtered. The sexual violence they experienced was, of course, connected to all of this other conduct, so they may not see it as their central loss or their violation. Developing an understanding of their understanding, doing this sense-making is critical. It's critical just for the respect that we owe them and how they view their lives and want to share it with us. But also as a purely legal matter, it's critical to draw connections between sexual violence and other atrocities arising in a conflict. This must be articulated clearly in a case, or else judges may see the sexual violence as random, unrelated, and thus not part of the overarching criminality. That's where your charges fall away or are denied. That's where they fall away in a conviction because the person isn't seen to be responsible for that thing also. Third, conflict-related sexual violence survivors' clocks are not often in sync with the courthouse clock. I actually tried to generate an AI image for you about this. It came close, but it wasn't good enough to actually show you. But if you imagine, right, there is a clock that we run on in courts. Sometimes there's time pressure, there may be political pressure, there may be just deadlines where you're balancing many cases. Survivors aren't on that timeline, of course, right? And that may dictate who's willing to come forward and able to work with you and who just simply is not ready. There's a natural gap between the preparation, filing, and pacing of a case and what survivors of atrocity crimes are ready for. They need personal, psychological, and social readiness, right? I mentioned the chatting women in the Senegalese courtroom. They were able to come forward once they saw that the trial was happening. But I also recall Bosnian women in her 70s who waited for her husband to pass away before speaking of rape she had endured decades earlier. And by then, the case that she could have joined had already passed. These clocks aren't always in sync. They also need safety. Disclosure of conflict-related sexual violence doesn't happen in a vacuum. Is the society ready to hear and protect? Are there laws and structures in place to support them? Will there be risks and personal cost, or even in some cases, penalty or prosecution if people come forward and disclose without those protections in place? What is the responsibility of a justice system to provide that? Finally, the issue of prioritization. Survivors of all atrocity crimes or even humanitarian disasters have evolving needs. Right? In the context of acute conflict, physical safety might be paramount. Family unity is a major concern. In the immediate wake of violence, one may seek medical care or shelter, and needs continue to involve a reshuffle in displacement and resettlement. People may prioritize food rations, shelter, and schooling for their children before they even think about accessing formal justice. The point is, seeking legal aid or joining a case or speaking with an investigator may not be front of mind for most survivors of conflict-related sexual violence until their other pressing needs are met, and that can take years. So sometimes being a survivor-centered means waiting, perhaps simply not asking someone to speak at all. Survivors' needs and priorities for justice are diverse also, right? Holistic justice includes aspects of correction beyond retributive justice, and, at a minimum, it includes the restoration of individuals to the state and the health that they were before the atrocities were committed. So, what are the forms of justice that do not have to come from a courthouse, and how much of that can we deliver? In a recent global study, the Global Survivors Fund, of course, gathered the top 10 priorities survivors of conflict-related sexual violence identified from around the world. Access to formal justice was indeed on that list, but it was outshadowed by many other things: access to health services, economic support, education, public acknowledgement or memorialization, safety and security, psychological support, community reintegration and acceptance, housing and property rights, cultural and symbolic measures. Clearly, there are aspects of justice writ large that can and often must come from beyond a tribunal. And so often it is civil society or humanitarian agencies providing all of this. States themselves have to step up and take responsibility for more, including for administrative reparations and essential law reform. So, in conclusion, I just wanted to address the tension between expedience and survivor-centeredness. Pushing for more expedience in the justice sector and taking a survivor-centered approach presents a tension, but they're not mutually exclusive. Concerns about rushing survivors to testify or potential re-traumatization are indeed legitimate, but it does not mean that we should simply back away from conflict-related sexual violence accountability because it's too hard or it's too risky. Instead, it's our responsibility to create the conditions under which survivors of conflict-related sexual violence can feel and actually be safe in coming forward if they wish to. Can we leave the metaphorical courthouse door open for longer? Or, if not, can we build additional courthouses so survivors who feel ready later can still engage a legal mechanism? Can we provide more holistic justice through interim or collective reparation so that more survivors can access the support and healing they see as an actual form of justice, even if they don't individually participate in a trial themselves? The answer to all these questions is yes. I want to leave you with 4 recommendations as to how. First, everyone in our organizations and institutions and referral networks, regardless of function, should be trained on and sensitized to gender-based violence generally, and how to create a safe, enabling environment for survivors to disclose it. This means basic training for documenters, investigators, prosecutors, judges, interpreters, our paralegals, our security guards, if you work in a shelter, your cook, our receptionists, everyone. In addition to this, additional in-depth periodic and iterative training for relevant staff with inputs from local experts familiar with social norms around gender, sex, and violence. This all-of-team approach is critical for deeply stigmatized or difficult truths like conflict-related sexual violence for at least 2 reasons. One, and I take this from just multi-country, multi-year study we did on barriers to disclosure. We never know when or to whom or why a survivor might choose to disclose their past experiences. It's not always the lawyer or the psychologist who has an appointment to meet with them. Right? Sometimes it's a security guard who's from the same tribe. Sometimes it's the cook that they actually have to spend time with in the kitchen in order to be a resident at the shelter. And second, the smallest sign of receptivity or discouragement from one person at one step of a process can influence whether that survivor and how that survivor chooses to proceed. In these processes, we are all downstream of someone else's actions. Second, we must build sensitive processes and practices within our institutions. In early stages, and in addition to ensuring competence to conduct a trauma-informed interview, of course, we must be prepared to consistently conduct vulnerability assessments prior to any engagement so we can proceed safely with the survivor's needs in mind. We should establish respectful and regular contact and community outreach, ensure that we have real working referral pathways in place. So we're thinking about and creating safety processes should we start engaging individuals in a community. We should also conduct a gender analysis and consider gender-based crimes at the start of every investigation and in every case hypothesis. So we're thinking about it and creating opportunities for survivors to come forward from the very beginning, and it's not an afterthought. In doing so, we also need to take an intersectional approach to understanding justice in this sense. It will so often be true that survivors, even within a single conflict or a single geography, are differently situated because of who they each are. They might be different facets of their identities. Are they indigenous? What gender are they? What religion? What political opinion might they have? How are they seen? They may face specific forms of oppression and discrimination before, during, and after the conflict, and this affects not only what they experienced and why, but what they need now and how they want you to interact with them. Once proceeding to trial, lawyers should take advantage of procedural rules to protect vulnerable witnesses. For example, do we take time to familiarize them with the courtroom? Do we explore options of testifying in camera? Can we apply for measures that allow for the use of recorded testimony to spare them a full retelling in court? Finally, we must offer meaningful witness protection, not only through the duration of trial, but also after, considering the potential lifelong risks certain survivors may face because they engage in a legal process. Resources are, of course, limited and creative. Third, we must be innovative in expanding the evidence that can prove conflict-related sexual violence crimes so that cases can progress. Victim testimony at trial will always be important. We always need it. But it's critical to think expansively about other forms of evidence that can carry water in a trial. For example, relevant support might come from open source material. What are the indications of gendered harm surfacing on social media, for example, either posted by witnesses to a crime or perpetrators themselves? Shockingly, it happens, right? One might seek expert testimony about gender norms or the historical or cultural significance of certain acts of violence within a context. Or perhaps it's possible to secure evidence of general trends from healthcare facilities or shelters that provided services in the immediate wake of conflict or upon release from detention. Fourth, we must continue to broaden and strengthen the justice ecosystem. I mentioned that in addition to international criminal tribunals and accountability mechanisms, we're seeing more national courts take up these cases. It is incredibly exciting to see that, and I admit I'm not familiar with Australia's position with respect to universal jurisdiction cases here, but it would be very exciting to see the courts of Australia take an active role in the region and use the principle of universal jurisdiction to take these cases here, even if the crimes themselves didn't occur on your soil or to your citizens. Some court doors are open for a short time, others for longer, and survivors need all of these options. So delivering justice for conflict-related sexual violence does indeed take time, but this does not mean we should be passive, just waiting for Kairos to happen, that perfect alignment of stars. We each have some control over some things. These next 2 days, I look forward to learning from so many of you about the work you are doing, and then let us pull some stars that we can reach, right? And bend time towards the justice we seek together. Thank you.